Well, good afternoon, everyone. It's now the 6th of December. I hope we're all starting to feel a wee bit festive. But before we abandon the work ethic completely and embark on a Christmas fest, welcome to this afternoon's webinar, which is on the scintillating topic of the new UK Subsidy Control Act 2022. What can public money be spent on and when? So your team this afternoon comprises myself, Jackie Maguire, and my colleague Jamie Dunne. Thanks. So without any further ado, I'll hand over to Jamie.
Thanks, Jackie, and thank you for being so specific about my role here. So yeah, what are we going to cover today? Well, first of all, what is a subsidy? What the definition of that is under the legislation when the legislation is triggered effectively. What to think about when giving financial assistance to an enterprise, and when that definition is triggered. What routes there are when awarding a grant, so the different options for how to go about doing this. And then what we've labelled as what happens when it goes wrong. Slightly more nuanced than that, as you'll see. But yeah, that's the overview of today. So starting, I think, with the sort of background to how we get to where we are today. State aid law. Now, a lot of EU law, when Britain left the EU, a lot of it was copied into UK law as retained EU law. As you'll know, state aid law was not amongst those things. So state aid law was repealed in the UK from the get-go and replaced by this new regime under the Trade and Cooperation Agreement between the EU and the UK, so what we refer to as the TCA. And the regime under the TCA, looks very similar to EU state aid law, some different terminology, but there's still a definition of a subsidy that looks a lot like a definition of state aid. Those principles, services of public economic interest, broadly equivalent to SGEI under the old regime, allowances for aid in emergencies. There's still de minimis rules, higher than they were before, but still calculated over a 3-year period, now measured in special drawing rights or SDRs, and potentially a lot of scope to change how these are interpreted. Now, the Trade and Cooperation Agreement was given direct effect in UK law by the EU Future Relationship Act, section 29, until and unless a more specific regime for subsidy control was put into UK law to replace that. And that more specific regime then is what we now have in the form of the Subsidy Control Act 2022. So, unpacking that a little bit, got royal assent in April of this year, and in that period we've gradually seen the sort of broader landscape of different parts of the new regime emerge, be consulted on and fall into place. And now we're at the point where everything has now been appointed to come into force on the 4th of January 2023. So we're in the final innings. This is the regime about to kick off. This is the more detailed domestic regime that the TCA allows for. And as part of that detail, you may not be surprised to hear there is an element of gold plating. There's an element of the UK government and parliament having taken what the UK has committed to at an international level and added some additional features to it, which make it slightly more than what we were obliged to do, and therefore slightly more than either state aid or the TCA would themselves require. So the principles and rules set out in the Act apply with some modifications to subsidies that are provided by devolved primary legislation. So if the Scottish Parliament passes legislation that involves a subsidy, or the Welsh Parliament and the Northern Ireland Assembly, then these rules will apply to those. They do not apply to subsidies that arise by direct result of UK Parliament legislation, although that can be referred to the CMA for an opinion if the UK government thinks it is appropriate to do so. And there are these different possible routes under which grants can be given, financial assistance can be given, and we will come back to what those look like in that section today. So to map out then where we are with the broader regime, obviously we all know that we've got this act that was passed earlier this year that's coming into force, and that act is supported by what I've broadly set out here is as four different pillars. They are not. Do not view that as too literal. They are just 8 different parts of supporting legislation and guidance. They are there to help, but the relationship to each other is really only through the Subsidy Control Act. So first of all, we've got 4 sets of regulations in those sort of teal, duck egg, take your pick colour boxes, and those regulate schemes of particular interest, so things that are subject to particular scrutiny, how to calculate some of the values of subsidies, the requirements for providing information, the transparency regime, and information gathering powers. And we'll explore some of these points in a bit more detail today. Also supporting the Subsidy Control Act, there's statutory guidance, which covers the whole regime. There is CMA guidance on the operation of the Subsidy Advice Unit. So that's not statutory, that's the CMA's own internal published guidance about how the Subsidy Advice Unit will operate when it gets the power to enforce the new regime, which it will have from it coming into force. There is a standard principles assessment template provided by BEIS. A lot of public authorities have their own assessment templates drawn up perhaps during the TCA applicability period, but there is one to maybe, if you want to compare what you've done to that, you may find that the one you've got is better, but it is there anyway. And illustrative streamlined routes. So I'll explain what streamlined routes are in a moment, but what we have published are not the streamlined routes that are actually created, but an idea of what they will look like when they are. So to look at streamlined routes in a little bit more detail then, what a streamlined route is essentially a subsidy scheme that is created by the UK government and essentially says these subsidies, any subsidy you want to make under this streamlined scheme is pre-cleared. So this is a bit like GBR. This is something that has already been done for you. And these subsidies, if a subsidy is awarded under these, then you're good to go. You do not have to go through the whole process of setting it up yourself. So those will include, according to streamlined routes, things like research and development and clean heat, but more broadly, we can expect others about green energy, levelling up programmes, that kind of thing. That's the idea that the UK government has given about what these things will be. We don't have them yet, but they're on their way. It's also possible under the Act for the devolved governments, so the Scottish, Welsh, and Northern Irish governments, to create their own streamlined schemes, and those will apply within those devolved jurisdictions. So the Scottish government can make streamlined schemes that can be used by public authorities in Scotland. We don't have, at time of going to press, even illustrative versions of those yet, but we can expect that they're in development as we speak. And those can be used again by public authorities to give a subsidy without carrying out an assessment from the start. There is also that statutory guidance that I mentioned, and it does go into a lot of detail. It is very lengthy. It is actually very helpful. I shouldn't sound so surprised, but it's great. Helps understand whether there's a subsidy, how the principles are meant to work in practice, how the rules are meant to work in practice, how the exemptions will be interpreted, and how some of the other broader parts of the regime will be used. And as statutory guidance, it's a really useful steer on what the proper interpretations of those different provisions should be. There are no big surprises in it, but it is useful nonetheless. And you are required as a public authority, if you are one, when making a subsidy, to have regard to that guidance and what it says. And I'll explain a bit more in a second how that comes into play. So what is a subsidy then? What's the definition of a subsidy? Basically, Section 2 of the Act sets out 4 cumulative criteria, which, if they are all satisfied, something is a subsidy. So financial assistance, which is, first of all, given directly or indirectly from public resources by a public authority. So that might be a grant. or it might be something more contingent, like a guarantee. It can be foregoing revenue that's otherwise due. So if you're expecting a payment to be made by a developer and then you waive it, that can be a subsidy because you're foregoing that payment. And the provision or purchase of goods and services as well. So you're basically spending money on something. The second criterion is that it confers an economic advantage on one or more enterprises. I should mention these coloured terms are ones that I'm going to unpack in the next couple of slides. That's why they are highlighted. So an economic advantage, as I say, has to be conferred, and it has to be conferred on an enterprise. The subsidy, for something to be a subsidy, it has to be specific. So it has to benefit one or more enterprises over others. With respect to goods or services. And then D there, it has to be capable of having an effect on either competition or investment within the UK, or competition or investment, trade or investment between the UK and another territory with which the UK has a trade agreement, basically. So that second point is really state aid, but that first one I'll come on to in a sec is a little bit more gold plating. So in terms of when something is coming out of public resources by a public authority, broadly, I think we can expect this to be viewed as similar to the state aid test, so granted by a member state or through state resources. A public authority includes any person who exercises functions of a public nature, so doesn't itself include parliaments, but those are caught elsewhere. Public resources is funds administered by the UK government, devolved governments, local authorities, and includes where they are given indirectly. So they may be awarded to another public body, or they may be awarded to a private grant administrator or whatever, and then passed on to an enterprise through that. It will still be a grant coming from the public authority. And I think that this is the interesting part of the test, really, is this last bullet here. Financial resources that are given by a public body through another person who is not a public body are treated as being given indirectly by the public body if the decision to give the grant is in substance a decision of the public authority. And I think it's useful to pick that up. It's not about whether the money is public money, it's about who exercises the decision over who it gets given to. So if that decision is taken out of the public sector's hands, then this will not be triggered even in that indirect interpretation provision there. So economic advantage, again, I think we can view this as broadly speaking equivalent to the regime under state aid. Financial assistance must essentially be granted on favourable terms. And section 3.2 of the Act is really useful. It essentially puts the MEOP test, the market economy operator principle, on a statutory footing. So rather than looking at guidance or anything like that to identify when an advantage is given, section 3.2 tells us that financial assistance isn't treated as giving an advantage unless the benefit is on terms that are more favourable to that enterprise than the terms that might reasonably have been expected to have been available on the market. So that is the test we are now applying as the new MEOP, and it essentially looks very much the same. So that approach can still be taken, and I think is a really useful one, particularly when what you're talking about is things like loans or leases or anything like that, to establish whether or not a subsidy is present. When is the recipient going to be an enterprise then? This is section 7, and this is about whether a person or group of persons under common control is engaged in economic activity that is offering goods or services on a market to the extent that they are doing so. So similar again to what we're used to under state aid law. Public bodies that are on markets, so think about your ALIOs that are running leisure centres, for example, they are engaged in economic activity, they are market actors, and granting them funding may constitute a subsidy. Now, we then look at the caveats to that, the first one of which is that an activity isn't regarded as economic if or to the extent it's carried out for a purpose that isn't economic. And I think it's useful to sort of view that a little bit as being equivalent to the regime we're all used to with regard to when public bodies are performing public tasks. So we're used to under state aid essentially asking the question, when money is going from one public body to another, well, is that public body still constituting a public body? And there is state aid case law on this, or is it now an economic actor? And the question really will be a little bit similar to procurement, I suppose. Are they doing what they're doing because it's a public task, or are they doing what they're doing to make money? And there's a lot of complex stuff in there, but that is essentially where we're going to get to with defining an enterprise. And there will be room for all of this to be litigated, I suspect, in order to reach a landing on those. Lucky us. So moving on to when something will be specific. Essentially, it's selectivity. It's the same test as before. Is there a leg up here? Is somebody getting something, some sort of specific treatment, or is a category of them getting specific treatment, other than where that selectivity is inherent to principles that are part of the design of the arrangements? And really look at things like tax cases. Taxes will frequently be designed to affect one sector of the economy more than others, perhaps for behavioural reasons. And where that is the case, the design of a tax benefit that applies to, for example, that changes tax treatment of wine will be selective to wine producers or wine sellers, but that will be inherent to the design of that tax or that tax waiver. So that will not count as specific in the same way as some other financial assistance might. And then looking at the effect on competition test, I've mentioned the point briefly about how this is a little bit more expansive than arguably is at all necessary under the TCA, and certainly it seems to be more than we had under state aid. And the reason for that is this: that the TCA was about effect on trade investment between the parties. So the UK leaving the EU would have removed the idea that anything that's potentially of interest to another member state would automatically have been would have triggered this effect on trade and investment test. But nonetheless, the UK being party to the TCA, any grant could have triggered this part of the test if it would affect trade between the UK and the EU, and indeed the same with any other trade agreement that we have. So, for example, if money is being spent to subsidise wind turbine developers in Scotland, then there are wind turbine developers in Denmark who would also like to sell wind turbines to people in Scotland, and that would affect their ability to sell into Scotland at a competitive price, for example. But something purely local would be very unlikely to trigger that. And we do have a sort of background of purely local cases under the old state aid tests, where we'd say perhaps that setting up a coffee shop in my part of Edinburgh might not be likely to affect trade with the EU, because how many French cafe operators are going to have their noses put out of joint by a cafe in Edinburgh that is not going to, people are not going to be diverted from their cafe to that one. So there's no effect on competition. The difference is that what we've now done under the Subsidy Control Act is introduce this test of competition, effect on competition within the UK. And there's no definition of what that has to be within the UK. So it doesn't have to be between Scotland and England or between Edinburgh and Glasgow. It just has to be any effect on competition within the UK. So we've gone from a state aid test that felt almost axiomatic, it was automatically triggered by the spending of money, to a TCA test that was a lot weaker, to now having this domestic test, which again feels like it's likely to be triggered in almost all circumstances. If you are giving something that satisfies the other tests to be a subsidy, then almost by definition, it's going to manage to trigger this as well, because it's going to be selecting one recipient to get money that isn't available to somebody else. So this one, partly because it's new, partly because it's stricter, I think there's a lot really to be developed around this, but it is something to watch out for, particularly if you're thinking, that's not going to bother anybody because it's purely local. It's quite possible that the purely local rule is now gone entirely. So, so something to watch out for. So, what to think about when giving financial assistance to a business? What to think about when you are giving a subsidy? Well, first question, obviously, is it a subsidy? And there are those 4 tests. They are cumulative. You may trigger very easily 3 of them, but if you don't trigger the 4th, and quite often, for example, because of the market economy operator rule or something like that, or because the money is being doled out by a third party and this public sector doesn't have any control over it, then quite possibly you're not going to satisfy that definition. So it is case specific, and it is worth considering that on a case-by-case basis. But even if you have decided that you've triggered a subsidy, well, how are we going to go about awarding it? One way to do that is to think, well, is there a scheme? Is there already a scheme, a sort of overarching provision under which subsidies can be given? And I can award this under that. It may be a scheme that my public body has made, either in the past or now. Or it may be a streamlined scheme. It may be one that the Scottish government has made covering any public body in Scotland, or indeed the UK government has made covering any public body in the UK at all. So my Blue Peter badge there really is to say, think about whether there's one you've made earlier. Think about if there's an easier option than starting from scratch, because there can be. Then what's the value of the subsidy? So in sort of market economy case, or for things like loans and the foregoing of revenues and that kind of thing, you're not, just because you don't satisfy the market economy test does not mean that the entire financial assistance becomes the subsidy. Your subsidy is the difference between what the market would give the recipient and what you're giving the recipient. So if you're giving the recipient a loan on favourable terms, it's not the loan terms, it's the favourable bit that are the value of the subsidy. So that's what you're valuing. Your question then is it de minimis? There is obviously that de minimis requirement. Under the Act, that's set at £315,000 every 3-year period per recipient. That is set deliberately lower than the cap under the Trade and Cooperation Agreement to avoid too much worrying about exchange rates, albeit I think we've managed to exhaust a lot of that in the last year with market fluctuations, but there we are. Think about cumulation. You've got to take into account everything that the recipient has received from other public bodies too. There was an idea when we were developing this that cumulation might go. It was seen as a really awkward part of the old regime, and I've been in many rooms with people at Bayes and others where there was a sort of there was chatting about this, and really it boiled down to actually accumulation makes sense. You can't have a body that's going around the whole public sector getting grants from different ones without anybody ever adding them all together. So the accumulation rule is still there. It's still there for a reason. Take it into account. And then transparency rules about publication, I'll come back to a little bit, but they really kick in above 100 grand, even where you are awarding something under a scheme. The subsidy itself above that level still has to be reported. Apply the subsidy control principles. I'll explain on the next slide what they are, but they are there. There are different ones if the subsidy is for the purpose of energy environment projects or agriculture, but the general principles we will come on to. And then, is it a service of public economic interest? Is it, are you getting somebody else to, are you giving somebody else a subsidy to collect bins, for example, or to run a hospital or run a school? Because in those circumstances, there's a different regime that applies and really takes into account things like competition. So if there is a subsidy and you are granting it from scratch, or you are creating your own subsidy scheme to cover multiple subsidies, then you've got to apply the subsidy control principles. If you're using a streamlined scheme or you're using an existing scheme, then somebody else will already have done this. That's the point of a scheme. But if you're awarding a new standalone subsidy, or you're creating a new scheme, then these are the principles to apply. So does it pursue a common or public interest? So it has to pursue a public policy objective and has to remedy an identified market failure or address an equity issue, levelling up, essentially. Bear in mind, not every time the market doesn't provide something is a market failure. Sometimes the market isn't providing something for perfectly good reasons. There will frequently be cases where if the market has decided that there's no reason to provide a spaceport in the centre of Edinburgh, then that's because the centre of Edinburgh is not the best place to put a spaceport. So the idea of spending public money on that is not necessarily to address a market failure, it's just to change the way the market works. Is it proportionate and necessary? So subsidies have to be proportionate to those purposes and limited to what is necessary to achieve them. It has to be designed to change the economic behaviour of the beneficiary, so it has to be steered in a way that changes what the beneficiary would have done anyway. If the beneficiary would anyway have built something or invested in something or provided a service, then what's the subsidy achieving? Similarly, costs that would have been funded anyway, so it's similar thinking, but this is more about specific parts of the costs that are being subsidised by the public sector rather than the ideas of the overall project. Moving on, is it the least distortive means of achieving the policy objective? So if there are other ways of achieving the policy objective, then pursuing a subsidy is not viewed as the best way to go about it. Is there an effect on competition and investment within the UK? Well, we've obviously established that there is an effect for the purposes of defining a subsidy. And so the principle that kicks in is the subsidy designed to minimise any negative effect on competition or investment within the UK? And it's important to bear in mind that just because you've got a subsidy doesn't mean it's an unlawful subsidy. Okay, so if you've satisfied that definition of a subsidy, you can still give it. You then just need to satisfy yourself when granting it that you've met all of these principles. So you've got to consider them, you've got to have a record of having considered them, you've got to have evidence to back them up. But if you can demonstrate that, for example, you've minimized the negative effects on competition, then it doesn't matter if there is an effect on competition, you can still grant that subsidy. And this is part of the point about the new regime. It's not like state aid. It's not that all grants are banned unless the Commission approves them or GBER allows them. You can give any grant you like that is a subsidy unless it is prohibited or unless you think, exercising your normal rational public sector judgment, that you do not satisfy the principles. So if you're happy that the principles are met, even if it's a subsidy, it's still in principle permissible. And similarly, the beneficial effects outweighing the negative effects, a balancing exercise to be reached. As with any public sector decision making, as long as it's reasonable and as long as it's evidence-based and as long as you're taking into account relevant considerations and ignoring irrelevant ones, then you can reach those conclusions. The next thing to take into account, even if you're satisfied all the principles are satisfied, is, are there any prohibitions in the Act on this specific subsidy? So you're not allowed to give unlimited guarantees, you're not allowed to give subsidies that require export performance, you're not allowed to have Buy British requirements in subsidies, and you're not allowed to have a condition that a business relocates existing business activity from one part of the UK to another. You're also not allowed to give subsidies for ailing or insolvent enterprises, so sort of bailout type subsidies. These are very similar to the old state aid rules, and you can continue to apply much the same principles. Then looking at some of the other points that we can take into account on the next slide, there are specific provisions for emergencies and disasters, and there is a very specific one for public health emergencies, which was designed effectively because everyone had COVID fresh in their minds, and this allows the Secretary of State basically to certify that there is a public health emergency, and therefore a lot of subsidy rules are suspended or permitted. The things are permitted to proceed. There's a national security exemption. There's also this a specific regime for legacy subsidies and schemes. I'll come on to them in a second. And there is this transparency database. So I've got a link there. If any of you, when we circulate the slides or the recording, if you click on that link, you will get nowhere. And the reason you will get nowhere is that you need to set up an account. If you've not already done so, and many of you may, you can set up an account by emailing Bays, and that will allow you to go onto that website and upload details of your subsidies, and the precise details, but they're available to see there. They're also available to see in the database regulations that I mentioned in an earlier slide. So what routes are there to giving grants? How do you go about doing this? Well, the first thing to think about is, do I have a subsidy scheme in place from before the new regime? So if you have created a subsidy scheme anytime up until the 3rd of January 2023, then you can continue to use it after on or after the 4th of January when the new regime comes into account. There is a grandfathering provision for legacy subsidy schemes. And you can still create new ones right now. You may not have time before Christmas, but it's in theory possible. If you don't want to use a legacy scheme, you may want to give a standalone subsidy. So if you are doing that, then you are just applying those subsidy control principles. Are you satisfied that you have the evidence to support those principles being met? And there are specific requirements for subsidies of interest or particular interest, which I will come on to in a second, or create a new scheme to cover a whole swathe of subsidies you want to grant. If you're creating a scheme, then again, you're applying the principles to the scheme. When designing a scheme, consider what the scope and terms of that will be. Everything basically has to be set up from the get-go. It's a bit similar to a framework, really, in procurement. You're setting all of the rules at the start, you're considering the principles at the start, and you're setting the requirements for when a subsidy that you grant will be covered by that scheme. You can then use it for any of those subsidies, but you can't use it for ones that are outside that those arrangements. But then what it does is it provides a sort of umbrella of protection from challenge or referral, and I'll come back to those points. You can also, obviously, let's imagine it's June 2023. You may create a new standalone subsidy, you may create a new subsidy scheme, you may have a legacy one from before January, or you may have one that you've created between January and June. So think about whether there is a scheme that you've created under the new rules as well that you might be able to use for any subsidy. And then finally, there's those streamlined schemes that I mentioned. Modifications of existing schemes are permitted, including a budget increase of up to 25%. So just be aware of that. Even if you've run out of budget, there are rules allowing that to be increased. So what is a subsidy or scheme of interest? So these are set in the subsidies and schemes of interest regulations, unsurprisingly, and basically where the value of the subsidy and related subsidies, so basically subsidies to the same person, are over cumulatively £5 million, then it will be a subsidy or scheme of interest, or one that involves relocation, rescuing, or liquidation, or a tax measure. And what is special about these is that you may refer them to the subsidy advice unit. So they're just kind of seen as a bit trickier, and so there is a specific setup for you to go to the CMA and say, are we okay with this? Does this break any of the rules? And if the CMA gives you the all clear, then there is a lot of comfort to be had in that. And then there's this other category of subsidies or schemes of particular interest. These are the ones that you must refer to the CMA before making them. If you do not, then they are effectively void. And where these kick in are any of these. So where the value of the subsidy and related ones is over £10 million, and it doesn't trigger rescuing or liquidation, and the subsidy is itself over £1 million. Where it's over 5 million and it's in a number of sensitive sectors, so a lot of sort of specific types of manufacturing, copper smelting and that kind of thing are listed here. It's very specific sectors which are particularly worrisome. And it is itself over £1 million and it doesn't involve rescuing or liquidation. And then finally, where the value is over 1 million and it involves relocation. really is the key thing there. This type of thing is seen as particularly high risk from a sort of UK internal market point of view, and so has to be referred to the CMA. Legacy subsidies, just another tiny bit on that. As I said, they're not subject to the Act's requirements if they've been made before the 4th of January, apart from the transparency requirement, and they can be modified as long as they have provisions allowing themselves to be modified. So you can create a scheme now that will then be grandfathered in as a legacy scheme, and you can modify it in June or August or in 2026. You can make these changes provided that the scheme you create now has provisions for that to take place. The regime also doesn't apply to anything that triggers the Northern Ireland Protocol or any of the legacy state aid provisions. And then very quickly, streamline schemes. These can be made by the UK government and laid before Parliament. Any modification has to go before Parliament, and these can be used by any UK public authority. The transparency requirements still apply above that £100,000 threshold. And really, this is, as I say, the new GBER. It's for routine projects to allow them to go ahead quite fast. And then lastly, what happens if it all goes a little bit wrong? So first of all, what happens if it doesn't go wrong, but it just gets a bit complicated? And what I mean by a bit complicated is that the CMA's Subsidy Advice Unit has it referred by BEIS. So BEIS, the UK government, in essence, may direct a public authority, it may order you to refer a proposed subsidy or scheme that is of interest. So bear in mind, you have an obligation to refer it if it's of particular interest yourself, but if it's of interest, then BEIS can order you to refer it. It can also do so if it thinks there's a risk of failure to comply with the Act. And it can also do so if it thinks that there will be negative effects on competition or investment within the UK. So there is a level of BEIS policing anticipated under this, and the guidance provides some idea of when that might be, when that type of concern might arise. You can also make a voluntary referral. As I mentioned, you can request a report from the CMA before you give a subsidy that's of interest, or you make a scheme that will allow subsidies of interest. The CMA has 5 working days to confirm it's accepted that, and then 30 working days to come back to you. So a little bit like the National Security Investment Act deadlines. And then I mentioned that there's this mandatory referral for particular interest schemes. If you make a scheme that is subject to mandatory referral and you don't submit it to the CMA, or you do but you don't fill in the form correctly, then you have made something that is prohibited. Whether or not it would be, whether or not the CMA would think it's prohibited, it is prohibited ab initio until the CMA effectively has cleared it properly. And there, that's equally true where you go ahead too quickly after the report. There are certain time scales within the Act for effectively cooling off purposes. The idea is that public bodies are given some time to think. And then there's challenges. So the Competition Appeal Tribunal has jurisdiction to review subsidy control decisions. So that can be a breach of the requirements of the Act. You've not properly considered or applied the principles. You've given a subsidy that's prohibited because it involves relocation or buy British or whatever. Or on general public law grounds, you've just been irrational, or you've taken irrelevant considerations into account, or you've acted for an improper purpose or anything like that. In Scotland, the CAT sits as a Scottish tribunal, so it applies Scots law rules of judicial review, and there is an appeal to the Inner House. So I've mentioned some of those judicial review provisions there, but it is the Scots public law interpretations that will be applied there. Who can bring a challenge? Well, an interested party who is aggrieved. It's a really interesting way of putting it. Really, any person whose rights may be affected, whose interests may be affected. So anybody operating in the same sector as the recipient is the most obvious person that might be aggrieved by the recipient getting something. The Secretary of State can also specifically bring a challenge. And it is possible to seek any remedy that is available in judicial review proceedings. Sometimes that may include damages, but it depends very specifically on what the case looks like. What else can happen? Well, the challenge has to be commenced quite quickly. They are effectively quite similar to procurement time limits. You've got to act, a challenger has to act speedily, essentially within a month. either of the publication of the referral report or of it getting a response to asking you for information. So following the transparency rules is important, partly in order to make sure you've triggered this. The CAT can order recovery, including interest, so it can order somebody to pay a grant back. That's also worth considering, including contractual or grant agreement provisions specifically to cover this for different circumstances, awkward circumstances. And then the next slide really is just saying there are issues here for recipients, clawback. There are issues for non-recipients around how quickly they have to act, and taking into account the Northern Ireland Protocol, and also judicial review. And then I've just kind of summarised the risks and issues on the next slide. I think the key one for you to watch out for is if people have a right to request information on subsidies you've given. It's a little bit like a new FOI regime that exists only for subsidies. So any FOI people and subsidy people have to be trained up on recognising these and what to do when they receive them. But we will leave that there. And if anybody has any questions, we can answer those. So, Jackie.
There's a lot in that, Jamie. So
Yeah.
some of it quite thought-provoking, and I like all the scary slides at the end. They're my favourite. So, Jamie, questions. One questioner is asking if they picked up correctly that funding provided by the Scottish Government to a public body, for example, can be subsidy if the public body is undertaking an economic activity, for example, investment. And if that is the case, what additional safeguards are required by the Scottish Government to undertake an assessment under the principles?
Yeah, so if you give money to a public body for it to pursue that relates to an economic activity, it's pursuing some market activity. Let's say a public body that's investing in a commercial real estate venture or something like that, then yes, it can be acting as an enterprise, and therefore the grant, even within the public sector, is viewed as being a subsidy. So what additional safeguards really to undertake? I think the key thing, first of all, is to identify when that's going to be the case. So what that looks like is a bit similar to the body governed by public law test under public procurement. So think about really whether they are pursuing a commercial or industrial function for those purposes. It will look similar. If it's something the public sector, the way that I tend to view it is, if it's something the public sector would have to do itself, then bin collection, say, then or the provision of schools. School buildings, then that kind of thing is not going to be operating on the market, whereas something like running a swimming pool might well be. So having a way to identify that, and then making sure that you've got provisions in any grant agreement, particularly around clawback, to make sure that if there is a need to get that money back, then there's a regime for doing that. But it is quite complicated.
An immediate question that should arise: if something is discretionary rather than a statutory duty, it's something you might want to look at in a wee bit more detail. Yeah. I think the next one comes down to this decision-making test. The question being, if a local authority gets capital funding, which constitutes subsidy, and the recipient who spends it confers an advantage, for example, by paying over the market prices for capital works, would that be captured?
Well, if the capital funding is itself a subsidy, then the tests will get applied at that point. So once a private sector recipient has received subsidy, then what they do with that money is kind of up to them. With it, there will be grant agreement requirements and so on. I think the issue with this is more around if you grant money to a developer, say, who is then empowered to select who they give that that too, and paying over market prices, they would be granting a subsidy to whoever they were paying over market prices to. I think it's really just important to have requirements when giving public money out that public money is spent well anyway. So you know, there are procurement rules that are triggered where you're giving money to do that, but also you'll want to secure best value for public money when you're rewarding that and have conditions for that. So by and large, if you're giving somebody else the power to make decisions on your behalf, you ought not to be giving them the power to make over market price awards anyway. But it is, they can confer an advantage themselves. It's only if they are conferring an advantage that you are effectively proximate to, you have control of the decision over, then that's where you'll trigger that.
I think I've got one final one for you. I'm going to do a bad thing by adding a bit of my own on to the end of it.
Shares principle, yeah.
Yeah. So the question is, if a public body awards a pot of money to an intermediary, and that intermediary then grants awards to businesses, but it's the intermediary itself who decides who to award to you, do you think the subsidy rules still apply? And the bit I would add on is, does it make a difference if the intermediary is acting within a set of guidelines that are produced by the public body?
Yeah, so this can come up with certain types of competitions and sort of grant administering bodies, your sort of catapult centres and the like, and essentially if they are deciding themselves who to award something to, but they are not a public body, and that you would have to consider that as well, but that's kind of on them. But if the subsidy isn't triggered and then by giving it to the intermediary themselves, and the intermediary then awards it to businesses, then I think that the subsidy control rules wouldn't apply if you have no control over that decision. But if you, for example, administer that decision in the way that basically I said in the answer to the last question, if you are setting out the rules for how they award that money, or the principles that they have to follow, then it probably will trigger that. But I think the question you have to ask yourself is, should you be giving money to an intermediary and not setting the rules for how they go about spending it? By and large, that will be quite an unusual thing to do for other reasons. So yes, I think there are ways to avoid perhaps subsidy control being triggered, but they are not necessarily good things to do under other regimes. So it's just something you've kind of got to think about all the different parts of the puzzle.
Well, one final question. I'm conscious of time. What happens if the private organisation you're trying to recover subsidy from can't pay because, for example, they're insolvent? Now, I would have thought you'd have carried out some sort of risk assessment before you're paying a subsidy over, and that's, you know, part and parcel of it, and there may be conditions attaching to the subsidy which make it easier for you to recover some of your money. But ultimately, I think, you know, given that there may be implications for the recipient, but if the recipient isn't able to pay, what happens in that situation?
I think there's two things. First thing is the recovery will take priority over any creditor. So if there's any money in the pot, then that's going to be paid back.
So it's a preferred debt, basically. Yeah.
But yeah, the other thing to bear in mind is that recovery moves with the economic activity. So if the insolvent enterprise sells the business, an administrator sells it to somebody else, then the liability to repay the grant can go with that, because it's not about the entity, it's about the economic activity that the grant has effectively propped up. So it's something to be aware of when there's sort of distress sales of such enterprises as well.
Okay, it's conscious of time, we're just a few minutes over, but I think that's us exhausted all the questions we have this afternoon, and I'm sure that Jamie's mightily relieved of that. Thank you to Jamie for all your efforts in terms of putting that together and delivering it. I hope people found. Thank you for your time this afternoon.